My paper's about about doctrines relating to the outer limits of national power, and so part of my paper deals with one of the doctrines that's been argued, and it came up a lot today, which of course I didn't ask you to read because I didn't know it was going to come up, but. I'll be glad to talk about that in the Q&A if you want to. But basically, there have been two theories offered. And one is sort of what I call the classical McCulloch theory, that the outer limit is you need an enumerated power, or you need a means that is plainly adapted to that power and is appropriate. Obviously, under that model, we've been arguing for 200 years, what does plainly adapted mean? What does proper mean? But the model, this is the standard model, and it's the model used by the Supreme Court. So I got originally concerned about this because of all these statutes and almost codes that Congress passes and powers that it exercises that just don't fit into this model. And I gave you all these examples, one being we all believe that there is a general national power over foreign affairs, but it's not explicitly enumerated in the Constitution. The immigration power is, I haven't seen any persuasive argument for how the immigration laws can be means to effectuate either one or more enumerated powers. You saw the argument in Zivotofsky between Justice Scalia and Justice Thomas on the passport power. It's another problem. The legal tender cases gave the Supreme Court an enormous problem, having paper money as legal tender for all public and private debts. In reality, this classical McCulloch model doesn't give us the outer limits of national power. And what I gave you here were just examples. There are others. There's another approach of scholars, and John McHale and Richard Primus are here, and they've been writing about this a lot. And that is using, in part, this problem of these implied national powers that don't fit into this understanding of McCulloch, and using the all other powers clause, the second clause of the necessary and proper clause. They argue that actually Congress has a general welfare power, or it's expressed in different ways, but a power to deal with all national matters of national import. And partly they rely on the preamble, so I really regret having asked you to read the portions of the article that I asked you to read about, because I talk a lot about the preamble and why I think this argument's wrong in the portion of the article that I didn't ask you to read. So, but if somebody asks me a question, I'll be glad to give you my answer why I think Bill Traynor and John McHale are wrong. Okay, so I don't accept this idea that there's a general welfare power, and I argue that at length. My own theory is that we've been making a mistake in reading the enumerated powers individually, and then in fact there are four clusters of enumerated powers. It's the theory of aggregate power and aggregating different powers, and there are four clusters into which almost all of the enumerated powers fit. In fact, when I went through the Constitution last night, all of them except one fit into these four powers. One being common defense, second being foreign affairs, the third being dealing with interstate conflicts, and the fourth being the creation of a national economic union. So I'm talking here not just about Congress, I'm talking about national power, I'm talking about the powers of all three branches of government. And when one looks at the explicit powers of all these three branches of government, all of those enumerated powers, except for one, the Republican guarantee, fits within these clusters. Now, is this an accident? So my argument is, first of all, with history, I go back, and again, a large part of this I didn't assign, but I go back to the actual functioning of the colonies under the old British Empire and the constitutional theories that were being developed by Americans in resisting parliamentary intrusions into their affairs. Basically, if you look at the powers that the metropolitan government was exercising, which the colonists accepted as legitimate, they are remarkably similar to what's in the Constitution. They're not, there are some additional ones that were put in because of experiences during the Confederation period. There's one put in the Republican guarantee because of the change in the nature of the government. But almost all of the powers that are in the Constitution are almost a straight line reference from this almost proto-system of federalism. It wasn't exactly federalism, but to the Americans, they thought, we're in charge of our internal affairs. We recognize the crown, the power of the crown, as having superintending authority in certain areas, including the veto power, but largely in areas, war and peace, the post office, regulating commerce, et cetera. And those are the powers that get into the Articles of Confederation, except for commerce. And those are the powers that get into the Constitution, with commerce included, and some others. So there is this historical trend of categorization of powers. And to me, it explains a lot as to how Article 1, Section 8 came into being after this debate in the convention between these two sides, one side wanting a general welfare power and the other side wanting enumerated powers. And I think the other side, appears to have won the debate. So my other historical reference point is McCulloch itself. So whenever I teach McCulloch, I always, I ask the students to identify what enumerated powers could justify this bank. And collecting taxes, right? Borrowing money, raising and supporting armies, right? They all say that. And then there's always a student who I usually ask to be my research assistant who says, but Professor, Marshall never explains how the bank is related to those powers. He doesn't do that. He goes into this long riff about implied powers, which he took right out of Hamilton's opinion, and which Marshall, by the way, is the one who made it public. Okay? He takes it out of Hamilton's opinion, and then he talks about the bank being an important instrument for the fiscal powers of the United States. And that's a term that's also used in the bank debates in Congress, where the Federalists are talking about some general fiscal power in the United States. And Hamilton developed this. Hamilton said to Washington, you shouldn't look at these enumerated powers individually. You have to look at them in the aggregate. And there is if you put together some of the enumerated powers, there is an aggregate fiscal power in the United States that authorizes the bank. So I think if you take a look at the enumerated powers, you see two things. And here I'm talking about, not just Congress, but the executive and judicial branches too. One is they fit into these four clusters of the powers, And secondly, these were the clusters of powers that were being exercised during the colonial period, which they regarded as valid. So where do implied powers fit into this? The implied powers I talked about. Well, there is that second necessary and proper clause, right? All powers vested in the government of the United States. And my argument is these powers are vested in the government of the United States. I don't agree with the proposition that the Constitution doesn't list any others. I mean, I think the three guarantee clauses, when something starts off that says the United States, and it's in Article 4, the United States shall guarantee Republican form of government, protect states from invasion, et cetera. That strikes me as a power vested in the government of the United States, which is enforceable through this second necessary and proper clause. I also argue in a part you didn't read about the treaty power, too, which requires the joint action of both the President and Congress. But in any event, I think that these implied powers, what they are all about is if it proves over time that if there is a general foreign affairs power and there are new methods necessary to carry into effect or make effective this foreign affairs power, Congress, by statute, under the second necessary and proper clause, can enforce it. And I think that that is the best rationale we have for the immigration laws. They serve multiple purposes, but two of the purposes they serve, protect national defense and foreign policy, neither one of those is by itself an enumerated power. And of course, they also relate to the naturalization clause. So that's what would be my part of what I do in the paper, is to explain how these implied powers fit with the enumerated powers, that they're means to carry out these four clusters of powers, viewing the enumerated powers in the aggregate and recognizing that they're interdependent. They're not, they're not standalone powers. Does that leave a lot of questions unanswered? Yeah, it does, which I say at the end, and in my most recent revision, I have even more questions about it. So I'm sort of in the middle between the enumerationists, which I don't think that can stand in light of these implied powers, and for other reasons that we can get into. Sort of in the middle between that, which I don't accept, and also setting the outer limits. I accept it if a law is plainly adapted to an enumerated power and is proper, it's constitutional. But I'm talking about the outer limits of congressional power. I don't accept that, and I don't accept what I think is a little bit of the other extreme, which is a general welfare power deriving either from the preamble or from other sources. So that's what the paper's all about. And if any of you are interested in the other portions, including the British history, the preamble, and all that, I'd love to have you read it and give me some feedback. I've gotten some wonderful feedback from some people who are here, which I really appreciate. And I should also say I really appreciate the opportunity to speak here, and I thank Mike and Stacy for all their work. It's been a great conference so far, and I hope I haven't ruined it.